Hi, good afternoon. Welcome to Estate Plan Blueprint, where we're going to be talking today on this live stream, on this video about see-through trusts. So if you're new to that concept of a see-through trust, it's a trust that's designed so that you get the same distribution schedule from qualified retirement plans as you would if you had a designated beneficiary. Okay, so why is that important? Well, if you just name a trust or an estate as a beneficiary of a qualified retirement plan, like an IRA or a 401k, 403b, something like that, then it all has to get paid out within 5 years. If you have a designated beneficiary, on the other hand, you can get a much longer payout period. For example, most people who are inheriting IRAs or 401ks get about a 10-year payout time period. With certain people, like the minor child of a participant or somebody who's disabled or chronically ill, something like that, certain special categories of individuals who were designated beneficiaries can get even longer payouts. They can get payouts, if you're a minor child, it can go until you're age 21 and then 10 years past that. So if you inherited at age 5, you could have, from the time you're 5 until you're 31. So it can be a lot longer than 10 years. But you want the longest payout for beneficiaries as you can. So this is why a see-through trust is important, because it allows the people inheriting IRAs and 401ks to get that longer payout, but still have all the advantages of a trust. So if you just name a trust and don't have this special requirements of a see-through trust built into it, it gets paid out in 5 years. But if you do have those special requirements of a see-through trust, then you can have a lot longer period. So you get more tax deferral, more growth. It's a lot more dollars going to your heirs. So this is why it's really beneficial for clients to be able to set up these see-through trusts. So let me give you an example of how this might work. So let's say we're doing estate planning for somebody who has a child that they want to leave funds to that's not really good with money. All right, so they need somebody watching over this, or maybe making distributions according to some sort of standard: health, education, maintenance, and support, but not letting the beneficiary of the trust get anything that they want out of it, okay? Because this person maybe needs some management. So you can have that trust in your will or your revocable living trust, or it might even have for responsible people, responsible heirs. We want to make sure that what we leave them is protected, right, from professional liability, or from creditors, or divorce, all these kinds of things that can happen. We want to build in some protection so that whatever the client is leaving to their beneficiaries is going to stay protected better. So these are typical types of trusts that we would have for the next generation to make sure that the money goes to them or for their benefit or gets protected. And it's typical to have a trust like that in a will, in a revocable trust that might control things like the house, investment accounts, and that sort of thing. Well, qualified retirement plans are in a separate category, right? Because they're not controlled by the will. They're not controlled by your revocable living trust, right? So they're in this special category over here. And again, if we're going to leave anything in a trust, it has to have those see-through provisions in order to preserve all of that growth and that tax deferral that we want to have in every case of qualified retirement plans. So you need this separate language for the retirement plan. And this can be done either if you have a revocable living trust, in the revocable trust, and naming, setting aside special provisions for anything that is named as a beneficiary in a retirement plan. So you set aside those special provisions in the revocable living trust. Or a lot of times, if maybe your client is using a will, right? You want to set up a separate standalone retirement trust or IRA trust. Okay, so those are the implements of estate planning that accomplish that trust. And the way it gets carried out in terms of the overall estate plan is that the designated beneficiaries of the qualified retirement plans have to change. So again, going back to our example, let's say we have a trust for, let's say child number one who can't handle large sums of money. And so we're going to put that into a trust, and we'd have all those regular trust provisions in the will. And then for the standalone retirement trust, we'd have those same trust provisions, but we'd also put in the provisions to make it a see-through trust. And that way, when we set up both of those documents, the amounts that are left either in qualified retirement plans or just through a will or revocable trust are going to have that same trust protection for the beneficiary. So we set up the trust or will, and then we set up the standalone trust or the provisions in the trust that meet the IRS requirements of a see-through trust, which I'll get to in a minute. And then we go back to the qualified retirement plan and have the client make the designated beneficiary consistent with what's been named in our retirement trust. So for example, let's say we've got that child number one, and we've got the trust provisions for them in the will or revocable living trust. And then their beneficiary forms for their IRA might say something like, my primary beneficiary is my spouse. If my spouse predeceases me, then it goes to the separate shared trust for child one under my separate plan retirement trust dated such and such. So you name it in the designated beneficiary form of the qualified retirement plan, and then you make all the right provisions in the standalone retirement trust or in the living trust provisions relating to that to make it a see-through trust. Once we've accomplished all of that, then everything can pass in trust to our beneficiaries the way we want it to, but we get the maximum growth and the maximum tax deferral. All right, now if you're a lawyer setting this up, what do you need to know in order to make this work? Well, let me show you the latest place that you can find this is under the proposed regulations of the Secure Act. And these proposed regulations came out in February of 2022. They're pretty easy to find on the internet. So look at proposed regulation 1.401A9-4F2. And it provides certain things that the trust has to have in order to be a see-through trust under the IRS regulations. So the first requirement is it has to be valid under state law. So it has to be a valid trust. Now, there is some provision in these proposed regulations that makes it clear that if you're in one of these jurisdictions where a trust isn't valid unless it has been funded, it's still valid under state law if it's not funded right away, which is typically what is going to happen with a see-through retirement trust, right? You'd set it up and you'd say this trust goes into effect when I die, and so if you die and your spouse is the primary beneficiary, then the trust wouldn't even go into effect at all. Typically, if we're a married couple, we're having them both do the same trust, so that whichever one dies second, that's when it goes into effect. So with a setup like that, it's quite foreseeable, of course, that you're not funding it right away. You're not putting any money in it. It's only going to get funded after you die, and you're the second spouse to die if you're married, and it gets funded. So in some jurisdictions, that wouldn't be a valid trust right away. So the regulations make it clear that if it's if it's that situation, if you're in that type of jurisdiction, the trust is still valid even if it's not funded right away. Okay, so the next thing is it's irrevocable or becomes irrevocable upon death. Next requirement is that the beneficiaries with respect to the trust interests must be identifiable. So if you're doing this type of trust, you should probably get some sort of resources that will help you to understand what all these provisions mean and how they apply, and give you some kind of forms. For example, Wealth Council is fairly well known. They have really good training materials on this, and trust provisions that are set up that you can integrate into your estate planning documents that would have the right provisions for this. The fourth requirement is that documentation must be provided to the plan administrator of whatever qualified retirement plan. And typically that has to be done by October 31st of the year following the year of the participant's death. So those are the requirements. Again, if you're going to be actually drafting one of these for the first time, find in your jurisdiction some good resources, some good materials to train you on exactly how to set this up, and to have some helpful forms and language that you can follow to make sure that when you set this up the first time, that you're putting all the right provisions in the right way, and that it is going to work for your client the way it needs to. A few minutes ago, I mentioned the proposed regulations under the Secure Act. So if you're kind of new to this area, the Secure Act was passed in 2019, and it changed the way distributions are made. Did a number of things, but one of the major provisions of the Secure Act was that it changed the way distributions are made under qualified retirement plans. And so now we're getting some proposed regulations by the IRS to explain some of the provisions of the Secure Act and explain in some detail how it works. For example, there were some provisions in the Secure Act that talked about distributions being made when a minor child becomes an adult, reaches the age of majority. And it wasn't quite clear on what that was. Is it 18? Is it 21? Does it depend on the jurisdiction? So the proposed regulations clarified that means 21. So the regulations are quite helpful in many areas. And one of the areas the proposed regulations addressed was the area dealing with see-through trusts. One of the helpful things it did was it recognized the two generally accepted types of see-through trusts. So those are a conduit trust and an accumulation trust. Now these types of trusts, conduit and accumulation trust, were trusts that grew up in the estate planning community, and they were kind of well recognized by the practitioners in estate planning. But now they've been recognized by the IRS. And in fact, the IRS has definitions of these. So a conduit trust is a trust, is defined by the IRS now, as a trust whereby the required minimum distributions that come out flow through to the beneficiary of the trust. So it could be, if you had a 10-year payout, whatever would be required would flow right through to that individual. And any other type of trust, any other type of see-through trust is an accumulation trust. So if it doesn't flow through, it can be allowed to accumulate. Most practitioners, and I think I share this opinion too, believe that now with the shortened time frames under the Secure Act for distributions, conduit trusts are of limited use. Maybe there might be certain situations where we might want to use a conduit trust, but most retirement see-through trusts are going to be accumulation trusts, simply for the fact that if you're setting up a trust and it's going to have provisions in there to protect those assets in the trust from the beneficiary themselves or from people that might want to take it away from the beneficiary. You're going to want to have it be an accumulation trust so that whatever distributions come out of the qualified retirement plan go into that trust and accumulate and then get distributed out according to the provisions of the trust, whether that's on a very liberal basis, on a very conservative basis, whether it's according to a standard, whether the beneficiary gets more control over what comes out of the trust. No matter what it is or how the trust is set up, an accumulation trust is that container that the distributions from the IRA or 401k go into, comes out of the IRA or 401k into the trust, and then is held and distributed according to the trust's standards. So it was very helpful for the IRS to recognize those two types of trust that we've all been referring to, and now get some sort of official recognition of it. On the downside of the proposed regulations, the way that distributions work has become much more complex, and so much so that I'm not going to try to conquer that in this video, but just to say that it now depends on who the beneficiaries are, whether it's a conduit trust or not, and whether the participant of the qualified retirement plan died before their required beginning date, before the date when they actually had to start taking required minimum distributions, or died after their required beginning date. So a lot of different variables there, and it's now become a lot more complex. So I recommend if you do estate planning, becoming very familiar with see-through trusts so that you can use them for your clients' advantages. But you really want to delve into those rules so that when you set it up, you know exactly how it's going to affect all of the beneficiaries, and you can advise your clients on how this is going to affect them and how it will be affected by the different rules depending on when somebody dies. All right, so this is a live stream happening on Monday, and I'm going to pause here to see if anybody has any questions. If you have any questions, you can go ahead and pose those now. And in the meantime, I'll mention that we do these live streams on YouTube, LinkedIn, Twitter, Facebook, and so you may have gotten an announcement. If you subscribe to the YouTube channel, Estate Planning Blueprint, then you can get notified, and anytime that we have a live stream, you'll get notification ahead of time so you can join us and hear it live. And we will later post this to YouTube as well, so that you can come back and watch it later if you happen to miss it. But it's good to hear all the content as it's coming out and be able to ask questions. So I'm not seeing any questions at this point. So at this point, I'll just I'll wrap up. If you have questions when it's posted on YouTube, you can put some comments in the comments section, and then I can answer them from there. So thank you for joining us. If you've gotten value out of this video, please like and subscribe. Hit the bell for notifications. All of that helps us to reach more people and get our message out so that more people can get this content as well. Thanks, and I'll see you in the next video.